Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to talk to you about pre-hearing briefs. What are they and how they can be helpful to you? And if you've watched some of my videos, sometimes I do refer to a pre-hearing brief. That is a written summary of the case that I submit to the hearing judge, usually a few days or maybe a week or so before the hearing. And I find that these briefs can be very, very helpful. It's not going to make the difference necessarily between winning and losing, but it can make the hearing go faster. And if there's a case that's maybe a little bit on the edge, it may push you in the right direction. But at the very least, it makes things go a little bit smoother and helps the judge understand the issues so that if you get nervous and don't testify as effectively as you otherwise might, I've already put in the brief kind of what I think you would want to say, and certainly subconsciously that helps the judge understand the gist of the case. So what is in a pre-hearing brief? And let's just go through what I typically put in mine. One is I'm going to identify the relevant dates, the date you applied for benefits, your alleged onset date, your date last insured. That's the date where when your SSD runs out, and any other kind of relevant date having to do with your case. And I've had a number of cases recently where the date last insured was a few years back, and my onset date was before the date last insured, and so I made it very clear in my brief that I understood that we had the need to prove that the medical evidence showed my client was disabled prior to his date last insured. And since that's a really big issue for the judge, I wanted to make sure the judge understood that I knew that and I was directing my evidence towards that. A pre-hearing brief will identify if your case is a Title II or SSDI, is it a Title 16 SSI, or is it what they call a concurrent claim, or both. And again, that just helps the judge make his or her decision that much more quickly and smoothly. I will use the pre-hearing brief to describe your past work, and I will go into some detail about what you did, and typically I'll ask my client to describe what he or she did, the type of machine he worked on, the physical nature of that. And the reason I do that is that a lot of the hearings, almost every hearing, the judge will use a vocational witness. Vocational witness will use a book called the Dictionary of Occupational Titles, which will describe a particular job and the requirements of that job. However, a lot of times I find that the actual job as performed is different than what is said in the DOT. The DOT in many cases is way outdated. It had been updated since 1980s, 1990s, so a lot of jobs in the DOT describe things that don't really exist anymore, and the job titles are still there, but the actual performance is different. So I describe what my client did as well as his or her job title, and I go into some detail about that along with the dates, because a lot of my clients don't remember the exact dates that they worked, so I will put the dates in there. I will identify my client's most serious medical conditions, and then I will state how those conditions, the symptoms, the medication side effects, the treatment impacts his or her capacity for work. Remember, that's the main issue in a disability case, why your medical condition prevents you from performing a simple entry-level type of job. So I just go out and say my client has been diagnosed with a herniated disc at L4, L5, L5S1. This is what it means in terms of his or her working. So that again, if you can't talk about it, if you don't remember what to say, it's already in the record in front of the judge. I will identify objective medical testing like an MRI, a CT, an ultrasound, a myelogram, just any type of objective test. I will identify that when it was done and the page number. It's Exhibit 4F, page 73, so that the judge can go right to that. Judges rely a lot on objective tests, and the more you can focus on specific objective tests, the exhibit number, it makes their life a little bit easier. They can point to that, makes it a lot easier for the judge to say, I'm going to go ahead and approve based on that. If you have voluminous records, and I've had a couple of cases recently with VA records, 690 pages of exhibits, or 1,000 plus pages of exhibits. If I can go through those exhibits and pull out specific pages that contain evidence that I want the judge to focus on, that helps you. So if I know that exhibit 14F page 697 contains a really relevant MRI report, or contains a report of a counseling session where you talked about wanting to hurt yourself or hurt others, things like that would be relevant to an evaluation of your physical health or your mental health, then judges appreciate they don't have to go through all that. And I've had a number of judges actually thank me for saving them the time to have to go through that, because here's a little secret: even the best judges don't have time oftentimes to go through every page of the record. So if I can go through it, identify specific things for the judge to look at, makes his or her life a little bit easier. I will use the pre-hearing brief to identify my theory of the case. As you know, if you've watched my videos, 3 theories that are possible. One is called meeting a listing. The second is called meeting a grid rule. The third is proving that your functional capacity has reduced your ability to work to such a level you would not be reliable. I will say, this is, we're not arguing the listing here. We're arguing grid rule 202.06, or we're arguing functional capacity, or we are arguing for a listing. I make it very clear what we're specifically asking the judge to do, so that he or she can look at that particular legal element and make a decision whether that argument is good. And realize that you can argue multiple theories. So you could argue for a listing and say, in the alternative, if the court does not find that we meet a listing, we would argue the grid rule, or we'd argue functional capacity. But I like to spell out what we are arguing as well as what we're not, to just not waste the judge's time. Pre-hearing briefs are generally not required. Some judges do require them, but for the most part, they're not required. I try to do them whenever I can, whenever the medical record is complete, whenever I think it's going to help my client's case, I will do it. Every once in a while, I'll make a decision not to write one because I think the medical evidence is not really that strong, and I don't want to emphasize that. I'm going to really focus more on my client's testimony. Those are tough cases anyway, but there's no reason to make it clear to the judge that we don't have a lot of evidence, or a lot of evidence going back to the date that we needed to go back to. But in most cases, it is appropriate to write a pre-hearing brief. I try to do them again whenever I can, but that's what I put in mind. So again, if you are proceeding, with an attorney in a different location, certainly ask your attorney about whether he or she likes to do that. I also send my clients the pre-hearing brief because I think it helps crystallize in their mind, A, what the theory of the case is, and B, that I know what I'm doing. And having that confidence going into the hearing is also a really positive thing as well. So that's my take on pre-hearing briefs and why I think you should have one in your case if at all possible. I hope you found this helpful. If you did like it, please give it a thumbs up on YouTube, like it on Facebook, subscribe to my YouTube channel, like our Facebook page, and visit my website at ssdanswers.com, and you can download my free Secrets to Winning Social Security Disability Survival Kit. A lot of great information there. You can also ask for a free case evaluation. I will do that if you're not currently represented. And again, if I can help you, please let me know. My name, again, is Jonathan Ginsberg, and I wish you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the Survival Kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.